Succession duties. The Commission has stated that there will be no particular advantage in levying succession duties in addition to estate duties. The reason adduced by the Commission is that both succession duties and estate duty fall on the same object, namely property passing on the death of the owner. As pointed out by the Commission itself, succession duties are leviable on the parts of an estate devolving on each of the successors, while the estate duty is levied on the estate in its entirety. The incidence in the two cases is different. The Commission apparently was of the view that the same object should not be taxed twice. This argument by itself is no ground for not levying the succession duties. Under the existing system of taxation, there are instances where the same object is taxed more than once, although by different authorities. To give two instances, excise duties and sales tax are levied on one and the same object. Again, immovable property is subjected to levy of property tax by the local authority, urban land tax, if any, levied by the state government, and again to wealth tax and income tax. Therefore, we are of the opinion that the question of levying succession duty requires examination in greater detail. Terminal taxes on goods or passengers carried by railway, sea, or air. A. Terminal tax on goods carried by railway. The only reason given by the Commission against the levy of terminal tax on goods carried by railway is that it would be administratively inconvenient, as it would involve collection of taxes at different rates according to destinations and separate accounting of receipts to be transferred to each state. It has, on the other hand, stated that it would be far simpler for municipal bodies to suitably modify their octroi or terminal tax rates, or preferably impose some levy on the sale or consumption of the goods entering their territorial limits. The Commission has started with the assumption that the proceeds from this tax would go in their entirety to the local bodies concerned, and that the state governments might not derive any benefit therefrom. We are not sure as to how far this assumption is justified. Even if it be assumed that the proceeds will be allotted to local authorities, it will to that extent relieve the state of its financial obligation in relation to the local bodies. This has been recognized by the Commission also. The levy and collection of any tax, particularly a tax of the class specified in Article 269, which has to be allotted to the states, necessarily involves some amount of administrative inconvenience and accounting, but this cannot by itself form any justification for not levying the tax. B. Terminal tax on passengers carried by railway. The Commission has estimated that the levy is likely to yield Rs 5 crores per annum, but it has stated that in view of the administrative difficulties and inconvenience involved in collection and the need to levy a corresponding tax on passengers traveling by road, it would not be worthwhile to levy the tax. Our views in relation to the levy of terminal tax on goods carried by railway apply here also. The road transport is already subject to a number of levies in the state. It's necessary, at least as an experiment, to levy the tax, and if after a period of 5 years it's found that the movement of passengers by railway has been adversely affected by the levy of the tax due to the non-levy of a corresponding tax on road transport, then it will be time to consider the issue. But the suggestion that the levy should not be made at all on the only ground that the states should simultaneously provide for a similar levy on road transport does not seem to be convincing. In fact, there is in force a levy of terminal tax on passengers carried by railway from or to certain places of pilgrimage or where fairs, melas, or exhibitions are held, namely the Terminal Tax on Railway Passengers Act 1956, Central Act of 69 of 1956. The Commission has referred to this Act also. Our view gets strengthened by the levy, which is already in force. All that is required is to expand this levy to include all other passengers carried by railway. C. Terminal tax on goods and passengers carried by sea. The Commission has stated that if a terminal tax is levied at rupees 2 to rupees 5 per deck passenger and rupees 10 to rupees 15 per saloon or cabin passenger, the yield is not likely to exceed half a crore of rupees, and that therefore it would not justify the imposition of such tax on this mode of transport only. This recommendation has to be read with its recommendation relating to terminal tax on goods and passengers carried by railway. In the view we take of the other two levies, we are of the opinion that there is justification for resorting to the levy of terminal tax on both goods and passengers carried by sea. Another reason given by the Commission against the levy of terminal tax on goods and passengers carried by sea is that goods carried by sea are already subject to port charges and other fees. A similar argument in relation to the levy of succession duties has been dealt with by us earlier in this chapter. D. Terminal tax on goods and passengers carried by air. The Commission has referred to the argument of the Government of India and the air corporations that there is no scope for this levy at present, particularly in the context of the need to attract more foreign tourists and to promote civil airline activity. While admitting that a moderate terminal tax on passengers carried by air cannot be ruled out, it has not recommended the levy on the ground that the annual yield will only be 2.5 crores. This argument is not very convincing. It's not a question of the yield alone which matters. Once the levy is brought into force, the scope for further increase and alteration will always be there. The thing is to initiate the move. As regards goods carried by air, the Commission has stated that it would not be advisable at this stage to levy the tax, as the mode of transport of goods by air is still not sufficiently developed. Transport of goods by air has come to stay. There is no reason why this field of taxation should not be exploited, or at least a beginning made. 3. Taxes on railway fares and freights. 1. Tax on railway fares. Tax on railway passenger fares was levied by the Railway Passengers Fares Act 1957, Central Act 25 of 1957, and the proceeds of the tax were assigned to the states at the percentages laid down in Section 5 of the Estate Duty and Tax on Railway Passenger Fares Distribution Act 1957, Central Act 57 of 1957. The tax was abolished by the Railway Passenger Fares Repeal Act 1961, Central Act 8 of 1961, which repealed Central Act 25 of 1957 and modified Central Act 57 of 1957 so as to confine the later act to the distribution of estate duty only. Central Act 57 of 1957 itself was repealed by Central Act 9 of 1962, which at present provides for the distribution of the net proceeds of the estate duty among the states. The Second Finance Commission was, for the first time, requested to make recommendations as to the principles which should govern the distribution of the net proceeds of the tax levied under Central Act 25 of 1957. It accordingly decided that the proceeds of the tax should be distributed among the states in the ratio of passenger earnings to be determined with reasonable accuracy by allocating passenger earnings among states on the basis of railway route mileage within each state, with due allowance for variation in density of traffic between the various railway zones and as between the various gauges in each zone. The Second Commission suggested that the proceeds of the tax be distributed in the ratio of the state-wise earnings so worked out and indicated each state's share as a fixed percentage applicable for 5 years from 1957-58. As already stated, the tax on passenger fares was abolished by legislation in 1961 after the constitution of the Third Finance Commission, but the Union government decided to make to the states an ad hoc grant of rupees 12.5 crores per annum for the quinquennium 1961-66, representing the average of the actual collections for the 2 years 1958-59 and 1959-60. In compliance with one of the terms of reference, the Third Finance Commission suggested that the distribution should be on the principle of compensation to place the states broadly on the same footings as before. The Third Commission has also referred to the complaint to the states that they have been deprived of an expanding source of revenue to which they were legally entitled under Article 269. The states represented to the Commission that the ad hoc grant, being a discretionary one, could be withheld at any time. The Fourth Commission agreed with the view of the Third Commission that the grants should be on the basis of compensation. The states almost unanimously represented to the Fourth Commission that the fixation of the grant at a particular level has deprived them of a potentially elastic source of revenue and have urged that the level of grant should be raised in the proportion in which the railway passenger earnings have increased since the merger. Again, the states represented to the Fifth Commission that the system of a fixed annual grant has deprived them of a potentially elastic source of revenue and urged that the quantum of the grant should be suitably increased each year, having regard to the growth in railway earnings from passenger fares. Some states suggested the reintroduction of the tax as an alternative. The Fifth Commission, while dealing with these representations, stated that the quantum of the grant would have been higher than rupees 12.5 crores if it had been fixed on the basis of actual tax collections during the 3 full years in which the tax was in existence, and that the subsequent revision in 1965 also was not related to the increase in total passenger earnings, but was based on the increase in passenger traffic. The Commission has stated that due to the substitution of the tax by a fixed grant, the states do not get a benefit proportionate to what they could have expected from the tax which was levied under Article 269, the proceeds of which are wholly assignable to the states. It considered the desire of the states for reimposition of the tax to be legitimate, but the Commission went on to point out the unsatisfactory state of railway finances and their increased expenditure commitments, and concluded by saying that there is no scope for the reimposition of the tax on railway passenger fares. It, however, suggested that the questions may be reviewed by the Union at a more propitious time. Like all other taxes specified in Article 216(9), the tax on railway fares is intended solely for the benefit of the states. The unsatisfactory state of railway finances can be no reason why the states should be deprived of a constitutional right. The tax levied and collected goes to the state treasury. We would, therefore, urge the reimposition of the tax. As regards the increase in the quantum of the grant in lieu of the tax, the Commission has made a pious plea to the Railway Convention Committee to take into account the views of the states and those of the railways. This is a tax which was in force, and there is no jurisdiction whatever for withdrawing it. This is a glaring instance of a power vested in the Union to be exercised for the sole benefit of the states being used to the detriment of the states. 2. Tax on railway freights. Here too the Commission has not given convincing reasons for the non-levy of the tax. It has referred to the position of the railway finances and to the fact that some essential articles like food grains, coal, etc. may have to be exempted. In any taxation measure, exemptions are inevitable, but there is no justification for desisting from the levy on that ground. As regards the railway finances, it has to be pointed out that it is a commercial concern, unlike the states which have to look after the economic growth of their regions. There can be no comparison between a commercial undertaking and a state government. The levy of a tax on railway freights stands on the same footing as a tax on railway fares. 4. Taxes other than stamp duties on transactions in stock exchanges and futures markets. 1. Tax on transactions in stock exchanges. The Commission has referred to the view of some states favoring the levy, while some others felt that the yield from the tax would not be substantial or that such levy would not bring any advantage to them in the absence of stock exchanges or futures markets in their areas. The absence of stock exchanges or futures markets in certain areas cannot be urged as a ground at all for the non-levy of the tax. In any federal setup, states should have the freedom to tap the sources of revenue available to them, which they consider more suitable and advantageous. There is no use trying to introduce rigid uniformity in this matter. The Commission has stated that the annual yield from this source would not be more than 1 crore of rupees. It has referred to the levy of stamp duties by the state governments in respect of transactions in stock exchanges and has concluded by saying that the rates of stamp duties could be increased. As we had occasion to point it out in relation to succession duties, the fact that the state government is entitled to levy stamp duties in respect of transactions in stock exchanges can be no ground for the Union refusing to exploit a potential source of revenue, the yield whereof goes in its entirety to the states. We therefore consider that at least as an experiment, the levy should be introduced. 2. Tax on transactions in futures markets. The estimated yield according to the Commission from this item would be only rupees 16 lakhs per annum. Sales tax, when it was first introduced, yielded only a very moderate amount. Futures markets are based more on speculation. This is a source of revenue which deserves to be exploited. 5. Taxes on the sale or purchase of newspapers and on advertisements published in them. After a comparison of the number of copies of daily newspapers circulated per thousand of population in this country with those in other countries, the Commission has concluded that since the tax on the sale of newspapers would be passed on to the readers, the tax would adversely affect newspaper readership. It has estimated the annual yield as rupees 3.5 crores. We would like to point out that a reasonable classification may be made in this matter. Readers of English dailies belong to a class of citizens which we consider can well afford to bear the burden likely to result from the imposition of the tax on the sale or purchase of such newspapers. The leading English dailies have a circulation extending to 2 or more states. Newspapers published in Indian languages may be excluded from the purview of the levy. We would accordingly suggest that the levy of tax on newspapers on this basis. The only item of tax specified in Article 269, the levy whereof has been recommended by the Commission, is that on advertisements published in newspapers. The Commission has stated that it is a reasonable source from which additional revenues assignable to the states could conveniently be raised. It has left the question relating to its levy, rate structure, exemptions, and other relevant matters to the Government of India for examination. It will thus appear that the taxes mentioned in Article 269 have not been exploited to any appreciable degree. This committee is of the opinion that every one of those taxes should be levied. If the levy and collection of taxes by the centre itself is considered inconvenient from the administrative point of view or expedient for any other reason, we would suggest that a general law may be enacted by Parliament providing for the levy and collection of the taxes specified in Article 269 through the agency of the state on behalf of the Union. This is the position in the case of taxes on the sale of goods in the course of interstate trade or commerce. There is no reason why a similar procedure should not be adopted in relation to the other items specified in Article 269. If considered desirable, the general law suggested by us may provide that those taxes would be levied and collected by the Union in any state only on a request from that state. Then the choice will be with the state, and the levy and collection of the tax will be at the instance of the state as an agent of the centre. Thiru Amal Roy, in his article captioned Federalism and Planning in India, their mutual impact, already referred to, has stated that an effective means of augmenting the resources of the states is the optimum exploitation of revenue earning possibilities of Article 269. Thiru G.S. Bhattacharya, speaking at the Indian Parliamentary Association Symposium held in New Delhi on the 3rd of May 1970, has referred to the general complaint of the states that the centre is not very enthusiastic about the realization of the taxes and duties under Article 269 because the centre does not derive any benefit from them. Almost all the answers received by us in response to our questionnaire indicate unanimity of opinion that the taxes specified in Article 269 should be transferred to the states. However, we do not agree with this view. Ever since the 1935 Act, taxes of this class have been in the central field for the reasons already mentioned above. The new additions to this list are those specified in entries 90, 92, and 92A. In view of their interstate base, they may continue to be in the Union list. At the same time, we suggest exploitation to the fullest extent of those taxes in the manner suggested by us. Surcharge on income tax. Articles 271 and 274 may be said to supplement Articles 269 and 270. Article 271 empowers Parliament to increase any of the duties or taxes referred to in Article 269. The whole of the proceeds of these taxes is assigned to the states, and Article 270, income tax, by a surcharge for the purpose of the Union, and the whole proceeds of any such surcharge form part of the Consolidated Fund of India. The states have been pressing for the inclusion of the surcharge levied under Article 271 also in the divisible pool. A suggestion was placed before the Third Finance Commission that the surcharge on income tax levied under Article 271, which had by then been in force for about 15 years, should be merged in the basic rates. It was stated that this would abate partly the impact of the loss sustained, as this would indirectly bring within the pool of distribution an excluded amount. The Third Commission, however, expressed its inability to deal with the point, as it was contrary to the express provision of the Constitution and outside its terms of reference. It was argued before the Fourth Commission that during normal times there should be no surcharge exclusively for the Union, and that if at all a surcharge was levied, it should, as a matter of course, be made divisible, being included in the basic rate after a period of 3 years. The Fourth Commission expressed its agreement in general with a view of the Third Commission on this point. The Fifth Commission also considered the point. The states suggested that the net proceeds to be divided under the head income tax should include a part of the whole of the proceeds of the surcharge at present levied on income tax for Union purposes, or alternatively, that the Union surcharge should be merged with the basic rates of income tax. In paragraph 3.21 at page 25 of the report, the Fifth Commission has dealt with the state's complaint regarding surcharge on income tax. It has taken rather a technical stand. Nobody denies the power of the Union to levy the surcharge under Article 271. The Commission has left it to the Government of India to consider the grievance of the states. The grievance of the states on this score has been voiced before all the 5 finance commissions, but no remedy has been suggested by any of the commissions, nor has the Government of India taken any steps in this regard. Article 271 is similar to the proviso to Section 137 and proviso B to Section 138(1) of the Government of India Act 1935. Article 274 provides inter alia that no bill or amendment which imposes any such surcharge as is mentioned in Article 271 should be introduced or moved in either House of Parliament except on the recommendation of the President. According to Clause 2 of Article 274, the expression, quote, tax or duty in which states are interested, unquote, means a tax or duty, the whole or part of the net proceeds whereof are assigned to any state. Article 274 is based on Section 141 of the 1935 Act. But there are 2 material differences between Section 141 and Article 274. One is that in according this previous sanction under Section 141 to any bill or amendment levying a surcharge, the Governor General had to act in his discretion. which meant that he was not bound to consult the central cabinet, much less was he bound by the advice, if any, tendered by it. But under Article 274, it's the Union Cabinet which ultimately decides the matter, and even consultation with the states is not provided for. The second difference between Section 141 and Article 274 is that under subsection 2 of that section, the Governor General had, before according his sanction, to satisfy himself, quote, that all practicable economies and all practicable measures for otherwise increasing the proceeds of federal taxation or the portions thereof retainable by the Federation would not result in the balancing of federal receipts and expenditure or revenue account, unquote. There is no similar provision in the article, and the Union Cabinet is not subject to any restriction or condition in this regard. According to the instrument of instructions used to the Governor General, he had to ascertain the views of the governments of the units before according his sanction. The fourth commission has gone into the need for consultation with the states before the President makes the recommendation to the Parliament under Article 274, while pointing out that although the procedural requirements of the article have all along been observed, it has stated that such observance may be capable of further improvement in such manner as would more fully carry out the purpose of the article and would convey greater reassurance to the states. With this end in view, the Commission has suggested holding of regular meetings at policy as well as implementation levels among other representatives of the Union and the states. The Commission considers that the proceedings of such meetings would be helpful to the President. It will appear from the reports of the successive finance commissions that the levy of the surcharge has been the subject matter of bitter complaint by the states. Thiru A.K. Chanda has, in his article already mentioned above, stated that although the central share of income tax is being progressively reduced by the principles enunciated by the successive finance commissions, still the centre's share along with the surcharge it levies remains significant. Writing in 1965, he says, it has, however, to be mentioned that there is some logic in the demand for merging the surcharge, which has been levied for over 15 years, on the basic rate. Earlier, the surcharge levied on income tax for some years was merged in the basic rate after the Second World War. This constituted a precedent for the demand. Although, technically speaking, constitutional, the continued levy of the surcharge for such a long period does not seem justified, especially when the states are excluded from participating in the yield of the surcharge. We recommend that the surcharge should be merged in the basic rates of income tax so that it can be shared with the states. The study team appointed by the Administrative Reforms Commission has observed, quote, it will further have to be considered whether such of the surcharges as continue to be levied by the centre for, say, more than 3 years should not be shared with the states, unquote. In future, no surcharge should be levied except with the consent of at least a substantial majority of the states. Taxes on the consumption of sale of electricity. The committee is not called upon to deal with the entries in the state list relating to taxes. It has, however, to be stated that in respect of a few items, the power of taxation vested in the state is subject to restriction by the Union. One such item is entry 53 of the state list, empowering the state to impose taxes on the consumption or sale of electricity. This power is subject to the exemption specified in Article 287. The tax cannot be imposed on the consumption or sale of electricity which is consumed by the Union or sold to it for its consumption, or which is consumed in the construction, maintenance, or operation of any railway. In the Government of India Act 1935, as originally enacted, there was no provision corresponding to Article 287. It was Section 3, Clause 3 of the India and Burma Miscellaneous Amendments Act 1940, 3 and 4, Geo 6, Chapter 5, which inserted Section 154A in the 1935 Act, and Article 287 is identical with that section. Accordingly, Section 3, Clause 1 and 4 of the Tamil Nadu Electricity Duty Act 1939, Tamil Nadu Act 5 of 1939 exempts sales of electricity to the Government of India for consumption by that government or sales to that government or a railway company operating any railway for consumption in the construction, operation, etc. of the railway from the imposition of the duty, and it also provides that the price charged on such sales should be less by the amount of the duty than the price charged to other consumers of a substantial quantity of energy. Again, Section 4 of the Tamil Nadu Electricity Taxation of Consumption Act 1962, Tamil Nadu Act 4 of 1962 prohibits the levy of electricity tax under that Act on the energy consumed by the Government of India or consumed in the construction, operation, etc. of any railway by that government or a railway company operating that railway. The grievance of the states has been that the heads of taxation allotted to them have proved inadequate to meet their liabilities. This committee itself has earlier in this chapter suggested remedies to overcome the financial imbalance between the states and the center. The committee, while discussing the distribution of legislative powers, has, in relation to entry 32 of the Union list, recommended that the exemption of Union property from taxation by states contained in Article 285 should be repealed. The exemption provided by Article 287 stands on a similar footing and may also be repealed. Concluding remarks on tax division. The financial structure of India is heavily weighted in favor of the center. The three major and expanding sources of revenues, namely customs, excise, and income tax, being on the Union list. Revenue resources allocated to the states are relatively unimportant and inelastic, and hence the shortfall between the total expenditure of the states, plan and non-plan, and receipts from taxes and revenues available is great. As it is, the Indian Constitution ignores the sound principle that the financial resources allotted to a government must, by and large, correspond with its executive responsibilities. With the advent of planning, the position has worsened as far in aid and deficit financing, both are for the benefit of the center. Grants. We have already dealt at some length with one source of financial assistance for the states to augment their revenues, namely taxes and levies imposed by the center and collected either by the center or the states. According to the provisions of the Constitution as they stand now, the states are entitled to the net proceeds of certain taxes, though levied by the center. Certain other taxes are distributed between the center and the states. We have made our recommendations for widening the base of devolution inter alia by including corporation tax, wealth tax, excise duties, customs and export duties, and surcharge on income tax in the divisible pool. Apart from this source, there is another way in which the resources of the states are augmented. This is by way of grants from the center. The only express provision authorizing such grants is Article 275. The material portion of the article runs thus, quote, "Such sums as Parliament may by law provide shall be charged on the Consolidated Fund of India in each year as grants in aid of the revenues of such states as Parliament may determine to be in need of assistance, and different sums may be fixed for different states." Unquote. Under Article 283, Clause 3, one of the duties of the Finance Commission is to make recommendations to the President as to, quote, "the principles which should govern the grants and aid of the revenues of the states out of the consolidated funds of India," unquote. It may be noticed that there is no express reference to Article 275, though, obviously, the grants in aid referred to therein would cover the grants under Article 275. Grants made under Article 275 on the recommendations of the Finance Commission could be described as statutory. The recommendations of the Finance Commission are, however, not given the status of an award, binding on the center as well as the states. We have proposed that the recommendations of the Finance Commission should be binding on the center and the states. Besides these statutory grants, that is, grants provided by the Constitution and made in accordance with the recommendations of an independent body appointed under the provisions of the Constitution, there are other grants made by the center to the state. These are generally described as plan grants, grants which will help the states concerned to carry out the schemes approved by the Planning Commission. Such grants are discretionary in nature and are being made on the recommendations of the Planning Commission. There is nothing in the Constitution to prohibit the Finance Commission from making recommendations for plan grants as well. The chairman of the Fourth Finance Commission was of the view that constitutionally the Finance Commission could recommend such grants, but actually the reference to the Finance Commission has explicitly confined the duty of the Commission to make recommendations only as regards non-plan grants. The only article whose support is sought to enable the center to make plan grants to the states is Article 282. That is an enabling provision which empowers the Union and the states to make any grant for any public purpose, even if the purpose is not one with respect to which Parliament or legislature of the state, as the case may be, may make laws. It is this article which has been utilized by the center for making conditional or unconditional grants to the states in connection with the plans. This article is based on subsection 2 of section 150 of the Government of India Act 1935. As already mentioned, the grants under Article 275 are being distributed on the recommendations of the Finance Commission, whereas the grants under Article 282 are being distributed on the recommendation of the Planning Commission. As pointed out by the Fifth Finance Commission, there is nothing in the language of Article 275 to exclude from its purview grants for meeting revenue expenditure on plan schemes, nor is there any explicit bar against grants for capital purposes. In the terms of reference of the first Finance Commission, there was no mention regarding plan expenditure, and that commission dealt with the revenue expenditure requirements of the states as a whole. The second Finance Commission was asked to take into account the requirements of the second 5-year plan as well as the efforts made by the states to raise additional revenue from the sources available to them. The third commission had similar terms of reference, and it recommended by a majority grants under Article 275 to the states so as to cover 75% of the revenue portion of their plan outlay. This recommendation was rejected by the Government of India. The Fourth Finance Commission was not specifically asked to take into consideration the requirements of the fourth plan. While it did not consider itself precluded from recommending plan grants, it did not do so because it considered it desirable that the Planning Commission should have unhampered authority in the matter. In the terms of reference issued to the Fifth Finance Commission, it was made clear that the Commission should confine itself to requirements, quote, other than the requirements of the 5-year plan, unquote. It was, however, argued before the Fifth Finance Commission that although the terms of reference precluded it from considering the requirements of plan schemes, they did not prohibit the Commission from considering increased expenditure so as to improve the levels of specific social services outside the plan. The Commission did not agree with this view and pointed out that this would blur the entire division of function between the two commissions. The point is whether Article 282 could be used for devolving non-statutory grants for plan purposes to the states. Thiru K. Santhanam, who was the chairman of the Second Finance Commission, while delivering a course of lectures on Union-State relations in March 1959 under the auspices of the Indian Institute of Public Administration, explained the scope of Article 282 in the following words, quote, "This was not intended to be one of the major provisions for making readjustments between the Union and the states. If that was the idea, then there was no purpose in evolving such a complicated set of relations of shares, assignments, and grants. There is no purpose in having two articles enabling the center to assist the states, one through the Finance Commission and the other by mere executive discretion. In the latter case, even parliamentary legislation is not needed. Of course, it will have to be included in the budget. But beyond being an item in the budget, no further sanction need be taken. Therefore, in my view, this article was a residuary or reserve article to enable the Union to deal with unforeseen contingencies. That was how this article was used both by the British government and after transfer of power before the first year of the first 5-year plan. Under this article, only some grow more food grants and some rehabilitation grants were given. This was specifically considered by the chairman of the Fourth Finance Commission in a separate minute recorded by him. He has pointed out that Article 282 contemplates a grant for a public purpose and has expressed his doubt whether grants under Article 282 could be made without such grants being tied to a specific public purpose. In his opinion, Article 282 was never intended for the purpose for which it's now being used. He has referred to the marginal note to the article and has stated that the article was not intended to enable the Union to make a grant to a state as such. He has suggested that a specific constitutional provision may be made to enable the Union to make conditional grants to states for implementation of any project, whether falling within or without the plan scheme on terms and conditions which would ensure a proper utilization of the grants. According to him, Article 282 could continue to be used for the purpose for which it was originally intended. The study team of the Administrative Reforms Commission, appointed to go into center-state relationships, has dealt with the scope, historical background, and the evolution of Article 282. According to them, the logical inference is that Article 282 was intended not to enable the center to make regular grants to a state, but serve as a residuary provision enabling the center as well as the states to make grants for any public purpose. Referring to the argument that the purpose of Article 282 is to validate expenditure incurred by the union or the state on a subject not falling within its executive jurisdiction, and that such expenditure should be direct and not necessarily limited to giving of grants, the study team has characterized it as an erroneous argument and stated that the article does not validate direct expenditure. In paragraph 4.7 at page 74, the study team has dealt with the views of the chairman of the Fourth Finance Commission regarding Article 282. The study team has concluded by saying that the legality of the present use of Article 282 cannot be questioned, but it has suggested an amendment of the original note to the article. The Administrative Reforms Commission itself, in its main report, has stated that when the Constitution was framed, recourse to Article 282 for the purpose of making grants for 5-year plans could not have been contemplated. Basu, in his commentary on the Constitution, has also dealt with the scope of the article. According to him, the word grants in Article 282 is not identical with the expression grants and aid in Article 273 and Article 275. But the word grant in Article 282 means expenditure. He further states that in that article, the word has the same sense as in Articles 113, 2, 203, 2, 204, 2, etc. And that if Article 282 simply authorized the Union to make grants and aid in favor of states, there was no need for the article at all, since Article 275(1) already confers that power. According to him, Article 282 authorizes the Union or a state to make direct expenditure on purposes which are not assigned to it by the federal distribution of powers, provided such purposes are public purposes. This committee is of the view that Article 282 was not intended to make grants tied with conditions to states. It was intended to enable the Union and the states to incur expenditure for any public purpose, although such purpose may be outside the legislative field of the spending government. The issue may appear to be rather academic. What the committee desires to stress is the point that the devolution of funds from the center to the states should not be at the absolute discretion of the Union. Tiruchanda takes a similar view. Quote, Article 282 empowers the Union or a state to make a grant for any public purpose when it falls under the area of their legislative authority. Though this article appears in the section dealing with miscellaneous financial provisions, it's being extensively used to regulate financial relations between the Union and the states. Though it was obviously intended to be no more than a permissive provision to meet a situation not otherwise provided, all capital grants to the states by the Union for implementing their respective shares of the 5-year plans are now made under this article as falling within the scope of public purposes. The grants made under this article are far larger than the total assistance afforded under other provisions governing the distribution of revenues between the Union and the states. The technical point has been made to sustain this procedure that capital grant is not a distribution of revenue. Practically, all grants for plan schemes are discretionary grants under Article 282. These discretionary grants have outstripped those recommended by the Finance Commission and have placed the states in the position of supplicants for central assistance. Moreover, the grants are conditional and circumscribe the freedom of the states in the matter of formulating plans according to individual needs. It's a disturbing trend to be taken note of that the non-statutory or discretionary grants have completely eclipsed the statutory grants. Discretionary grants constituted 71.3% of the total grants paid by the center to the states in the third plan period. Discretionary grants and loans together constituted nearly 70% of the total volume of resources transferred from the center to the states. The resources transferred through the medium of the Finance Commission aggregated to rupees 1,488 crores within a total transfer of resources of rupees 5,600 crores in the third plan period. The predominance of discretionary grants has given the central government a powerful leverage in influencing the policies and programs of the state governments, even in spheres such as education, medical, and public health, which are constitutionally within the competence of the states. Among the various factors which have been a constant source of irritation between the center and the states in the realm of finance and planning, the preponderance of discretionary grants should be assigned an important place. These discretionary grants have been given under Article 282 of the Constitution, which, occurring as it does under miscellaneous provisions, could not have been designed to be the principal support for state finances. Quote, it's clear that the scheme originally visualized in the Constitution for regulating the transfer of resources between the center and the states has proved inadequate. The fact that a significant part of the central resources to states is canalized on the recommendations of the Planning Commission and that this transfer is discretionary, conditional, and subject to fluctuations in the light of center's own financial position has further accentuated the sense of dependence of the states on the center. The committee is firmly of the view that grants by the center to the states should be made only on the recommendation of an independent and impartial body like the Finance Commission or similar statutory body.